date list on the court. My lords, to call upon criminal appeal number 12 of 2024. Thabiso Lekitla versus Rex Melons.
Mr. Court, my name is T-E-L-E.
Who doesn't know it?
For the record.
Oh, it is the record that doesn't know it.
And my little friend, Mr. Advocate Moahloli, and I appear for the appellant.
With LD.
That is so many.
I used to have a teacher by the name of Lekitla. So every time when I was asking for the stuff, hey, bring the Lekitla file. Which one is that?
May it please the court, my lord, I appear for the respondent in this matter. I am LM Mufidikwane.
Mufidix.
Yes, my lord. LM Mufidikwane. That's the court cases.
Thank you very much.
My lords, on behalf of the respondent, we apply that our late filing of the list of authorities, which was filed on Friday last week, be condoned. We have filed the notice of motion supported by the founding affidavit this morning, my lords.
I'm sure Advocate Italy would not say no. He would not say we should not lay our hands on the
I think so too, my lords.
I certainly wanted to bring as many as possible.
That's the court cases.
Thank you.
That's the court cases.
My lords, I have to deal with one housekeeping matter which is a source of great embarrassment for myself. The heads were prepared well in advance before the record could be prepared. That is the Court of Appeal record. And my junior was assigned to align the heads with the record, but he failed to do that. I suspect, as your lordships were reading through the heads, the references were made to page 26, 27, but those were not aligned with the current record. Yes, what I've tried to do, and I asked him last night to try and make an alignment for purposes of the hearing, and I apologize for the obvious inconvenience that would have been caused by that. My lords, the present appeal should be short, I would submit. The matter arises out of an application for postponement on the 2nd of September. And the application for postponement that was made by my junior, who was appearing alone at the time, generated a lot of debates between both the judge as well as my colleague. And in the course of the application for postponement, the judge came to a point where she suggested that perhaps it was time that my learned friend would be relieved of his duties, and then a Prodeo council would be appointed. And the matter was postponed on the initial day on the basis that a Prodeo appointment would be made by the registrar. Now, all those things do not seem to matter much when they are looked at in isolation. But the gist of the debate, whether robust or otherwise, is what is troubling when taken together with what happened on the 2nd and the 3rd of September. The learned judge appeared to have been of the impression that the accused person was simply playing a delaying tactic. He did not want the matter to proceed. And the language that she used, I submit, was not robust. Rather, it was one that went beyond what you'd expect from a judicial officer presiding over a criminal matter of the nature that is faced by the appellant. If I could perhaps just take your lordships to the record. Now, if you start at page page 91. The long speech by Her Ladyship starts at page 90. But I want to ask your lordships to look at page 91. Or perhaps let's start the sentence, the last sentence on 90, so that it makes sense as we cross over the page. At the very last sentence, she says, now we put you to terms to comply, and on the date of hearing you tell us things that shouldn't be privy to. I think she meant I shouldn't be privy to. That is a private relationship between you and your client, which I'm not going to entertain. More so where you say he's making means to come and pay. So, for the benefit of His Lordship Justice Mzonda, Justice Pandavestaden, the portions that are in brackets are intended to translate the portions that are in Sesotho. So if you read the sentence, you then skip the Sesotho version. You say, pay so as to how you pay each other with your client. So you read those in brackets. That should not it should not inconvenience the wheels of justice. If he hasn't given you payment, it's none of the court's business. Already the choice of words becomes glaringly the sort of words that the court does not use. It's none of the court's business. The courts don't say that. They don't say it's none of the court's business. It is actually the court's business. What is going on in court? What is going on in relation to the accused? That is the business of the court. And then it says all the court is interested in is that the litigant has briefed the counsel of his choice, because the same section that you've quoted of fair trial, there's something in the audible there. I think she was saying it entitles him to Prodeo, and he hasn't opted for that. I'm not going to take you through all the debate that passed between Malena Jr. With the judge, but the issue of Prodeo, I will just hint at, and then your lordships will see how it fits in. Now, and this is important, again, now when it suits him, he doesn't pay his lawyer. When it suits him, This is a trial fact who would be determining whether a person is innocent or guilty at the end of the day. If you go back in this record to try and find out where she gathers the notion that it is because it suited him not to pay a lawyer, you will not find a passage, a single passage, where that is supported. If I go back to the quotation, now when it suits him, he doesn't pay his lawyer, and this inconvenience also inconveniences the wheels of justice, and that is the rights of the accused. I don't think that section 12 talks to that, and the issue of you having interviews with him and so on and so forth, but by the look of things from your opening statement, it shows that at least as things stand as now, as we speak, we know his defense. So there is no prejudice that is going to suffer. The opening statement shows that extensive and intensive interviews have been held, so much so that as of now, as I'm seated here, I perceive that you are prepared to lead his case. Now, then she continues. So all these things should not have happened because a man, according to his own opening statement, he is joyfully employed. That is the constitutional right, unless I do not know the Constitution. I don't understand Dadelepedi. For your lordships, Dadelepedi refers to my junior, that's his first name. Now, the application was one for a postponement because the appellant was seeking for time to mobilize funds to brief counsel. But the learned judge, I submit in a very sharp manner, criticizes this very fact without the basis that it is because he is looking at his own convenience. Incidentally, while I'm talking about the postponement, I might just mention, my lords, that if you look at page 106, Her Ladyship, there creates an impression that he doesn't even know what Mr. Mulap was doing. My little friend Mr. Mulap was doing. Was he applying for postponement? Was he withdrawing? And so on and so forth. And at page 106, the record is not properly prepared in this sense because there ought to have been the numbering on the sides. There are no numbers. But I will trouble your lordships to count from the top of the beginning of the paragraph. 1, 2, 3, 4, 5, 6, 7, 8. The eighth line, yes. The learned judge appears to create an impression that she doesn't even know what's going on. She says, the Crown, to my understanding, is opposing withdrawal / postponement, or whatever this animal that Advocate Bulapo is referring to. It is a combination of two. And but of course later in the judgment now, if you look in the judgment.
So are we looking at just this sentence, or we go beyond?
Well, we can actually go beyond. Can actually go beyond.
The Crown, to my understanding.
Sorry.
The Crown, to my understanding, is opposing withdrawal / postponement.
Whatever this animal that Advocate Bolapo is referring to. It is a combination of the two. And this is, I understood the DPP or the administrative to be hesitantly postponed, and I take this from their words, or our witnesses are ready, and that the other submissions, blah blah. But what I wanted to direct your attention to, my lords, is that before I take it to the judgment, the judgment where she now says she had always been clear that this was an application for postponement. She no longer had any doubt. I just wanted to make the point that so when the ladyship was saying she's not clear whether it's a postponement or a withdrawal, perhaps in a sense it would have given a justification to try and clarify what exactly it is that was going on, and there's nothing wrong for her in clarifying that. But subsequently in the judgment, she specifically says, from the very onset, I was aware that this was an application for postponement.
Sorry, before you
Yes.
go to the judgment, seeing that you quote from the proceedings, is that at 95, page 95 of the record?
95, yes.
Yeah.
Yes, madam.
Yeah, the second quote there by the judge, and I see.
Yes.
And I see your face.
Yes. After that, as that one who have been briefed, at least you know the court, or this particular court. I don't take kindly to mijigis, to tricks. As an officer of the court and you're saying, give postpone, that means I should postpone my law. Because Hakisa on a Monday, you're saying I should postpone because you no longer have a Monday. But, yeah.
But my focus is more, and if I see your face.
Yes, yes.
So how is this court supposed to know what the face looked like?
So, yes.
Anyway,
Yes.
yeah, up to you.
What he was actually saying, Your Lordship, the context of it was this. She was actually saying, all right, you say you have not been remunerated for the service, and then you want a postponement on account of non-payment of fees. Now, I should not see your face again here. That is to say, because it will be you playing tricks on me. Because if you come back, the understanding is that you'll be playing tricks on me. You see. But the application for postponement from the very beginning was very clear that we asked for time to mobilize funds to brief senior and junior counsel in the matter. Okay. So yes, madam, and I want to take the judgment. In the judgment, if you look, Your Lordship, at page 52. 52, page 52. It is in the first volume. And at paragraph 1.5 of the judgment says the court then sought to determine the grounds upon which advocate the payee was postponing the matter. Ultimately, from the engagement that the court with Malapo.
You're reading
from page 52, para 1.5 of the judgment.
1.5. Okay.
Now, it says, and ultimately from the engagement that the court had with Advocate Malapo, the postponement was sought on the grounds of non-payment of fees. I'll refer to this engagement later in the judgment. We save to note that at this stage that the arrangement led to the conclusion that the postponement was solely sought on the grounds of non-payment of fees. I just want to see the exact paragraph where she actually said it. She was clear from the very beginning. Now, I think it's that way. Yes, I seem to have moved my finger away from that, but I'll get it. Where she said, in the judgment, where she specifically says she had been clear from the very beginning that this was an application for a postponement. Now, and a lot of things are said around the postponement. I want to perhaps, before I proceed further to discuss it, to say that we were not complaining about her discretion to refuse a postponement. That is not what we were complaining about. We understood perfectly well that she was entitled to refuse or to grant a postponement, depending on how she finds the reasons for the application. What we are complaining about are the comments that are triggered by the application for postponement in refusing the postponement. And I see that Madam friends for the prosecution are also laboring under the impression that we are complaining about the postponement. We could not have been complaining about that. The application for postponement, the first application for postponement, which was moved by Madam friend, Mr. Mulapo, was on the 2nd of September. And the matter was postponed to the 3rd of September to enable Prodeo Council to be appointed. Now, then on the 3rd of September, when the appellant was by himself, a postponement was actually granted, which was for the Thursday following the 3rd of September. So there had been a postponement that had been granted. So the instructions were given when after the postponement had actually been granted. That in view of the comments that the then judge appeared to have made in the course of the proceedings for postponement, leave me in apprehension that she may not be impartial. Now, the most important bit which I just want to touch on, I'm not going to go through all the things that we've argued. It's the aspect that the appellant is a member of parliament. That the appellant is a member of parliament. Now, and he protests that, but it is not fair to bring in the question of my office when I'm asking for a postponement. It is not correct, because the moment your ladyship is saying, I am playing delaying tactics, you are effectively saying, and when you bring in now to pair that with the question of my political office, you are creating an impression that I'm using my political office in this court to play delaying tactics. Indeed, when you look at the entire record of proceedings, the postponement proceedings, you will see that the dominant fact which influenced the learned judge to believe that the appellant was wasting time is because he's gainfully employed and earns a salary in Parliament. And maybe I should take your lordship.
Just stay with me there. And you know, Advocate Hlaele, when I read the record,
Yes.
and I sought to situate the comment about the appellant being a member of parliament,
Yes.
I understood that to be arising because the counsel was saying to the judge, the appellant did not have money to pay him, and therefore, and this actually took the judge to the extent of saying, if that is the case, let the registrar organize Prodeo payment. So I understood this aspect about you are gainfully employed, that you are an MP, actually to address the issue that you must be having money. That's what I understood. Any comment?
Yes, I want to input on that. Now, the application for postponement had been, we are not put in full funds. Not that we have not been paid at all. In other words, it is not that the appellant is unable to pay fees. It is that the fees that are quoted to instruct both junior and senior, he has not completed paying. And we're asking for postponement to enable him to do that exercise, precisely that. So that the very notion and the very idea that a member of parliament would be placed in a situation where it is suggested by a judicial officer sitting from the high bench that he has no money to pay to a point where he must now be given pro deo, in itself it's not a good suggestion. And
You mean political?
Well, perception. We're talking about the perception.
Yes, the ordinary people outside will say, hey, the whole member of parliament not being able to pay for his case,
And he's
pay for
like,
the lawyers, and he goes to court to seek a postponement and say you are.
pro deo.
And then running now. What about me?
Yes.
What?
And I saw that it creates an impression that it fits into the narrative that he's wasting time.
Yes, yes,
Yeah.
but counsel, if the appellant were the manager of Standard Bank or FNB, and the judge, in some rude language, say, "Don't talk to me about a shortage of money. You have a good job," would it be different?
No, it wouldn't be different. It wouldn't be different. It actually would be exactly the same. It's exactly the same.
No, but why is it wrong then? If she says, "I think you guys are tricking me," you say you don't have money, but you have a job. You're a senior officer in the bank.
Democratic, yeah, Paul.
No, I go back to the fact, that fact which the president, which I said
Yeah.
the president when he raised, that it is not that I don't have money. It is that I have not raised sufficient money to cover the brief of senior and junior counsel.
Yeah, but will the public not also say, how can this guy come and ask a postponement and says has not covered sufficient money, whereas he is a senior official in a big bank?
No, I'm saying that.
Except now, what are you hinting on some general distrust by the public of parliamentarians?
Yes.
And is that, if so, is that the judge's fault?
No. It would be pitching it too high to say it's a fault. It's not fault. It's understanding perceptions within which the judge operates, his court, her court operates. So it is not her fault. This is actually a situation where now you say, how would it come through from a reasonably well-informed a person standing and looking at the proceedings? And I submit that it would come out.
Yeah, but I'm saying this ordinary member of the public, reasonable, etc., will not think there's anything wrong with the judge saying that about a bank manager, but it is wrong to say it about a parliamentarian.
No, I've said, I think we have cross purposes there. I've said, Your Worship, that it is as wrong with the bank manager as it is with the parliament.
Okay,
Yes.
so it is wrong of the judge to bring in the person's income and job.
Particularly in circumstances where he's not saying, I don't have money. He's simply saying, sorry, my lord.
What was he saying? You're saying, Mr. Mulapa is saying, no, we have not been adequately, what was the phrase he used? We have not been properly instructed.
Yes,
What was it?
there's a
I
phrase.
think it is.
Yes. Let me just
Properly
one.
instructed, does it mean I've been paid a portion of it, or does it mean I have not been paid at all, or
It
does
actually,
it mean the litigant is unable to pay me, or, but he talks about money. It says, he
yes.
says I have not been properly instructed, by which I think ordinarily lawyers in this jurisdiction would understand that to mean I have not been paid.
Yes, but and the matter came up in the debate, and it's a specific mention that what was outstanding, he had paid part of the fees. And if you look at even the statements from the appellant himself, perhaps we should.
That was when he was appealing for
Yes.
himself.
Yes, and even earlier that came up, but I just want to put it in context. Now, the engagement starts from page 120. Let's see. 123. And then here the appellant is giving a report back as to what happened with the registrar. And then he says the long paragraph.
As I had been.
Yes, as I had been. But I don't want to read the whole thing. He later says that if he could be allowed an opportunity to meet with other legal representatives to avoid any inconvenience, with humility, my lady, may I be allowed on Thursday? I'm prepared and come with a legal representative to proceed. And then the following page. And then he says, okay, I have a few questions. Okay, he said, you have not paid him. Then he says, the fees were higher than expected, amounting to 150 to 200,000. And this is one aspect where the appellant we submit was now being oppressed. And then the leadership says, I expect an answer, not an explanation, because then I'm a bit slow. I'm a step-by-step person. I crawl before I walk. Do you appreciate it? I do, my dear. Then he continues. I am saying, Advocate Leperi is saying he has not been paid. He has not paid his office. Then the appellant says, part of the fees, my lady. And then she says, Advocate Leperi says you had not paid him. And that is so, my lady. You had not paid him his fees at all. The cross-examination. And then the following page, I paid part of my lady. And you have outstanding fees. This so, my lady. Your issue is that you want this court to postpone your case because by your own choice, you had elected a lawyer you cannot afford. So, and I submit, my lords, that already that conversation is one that I submit the court would not undertake. And then she says, once again there was another accuser. I was just not expecting this kind of fees, as I was already, and then the leadership stopped him and said, once again we have the problem of not answering the questions. If you don't understand, please ask, because you're answering. These questions will assist me in coming to a just and equitable decision. Before I get there, maybe I should ask, what are your means? What is the means of your means of income? And then he says, it is common cause, I suppose, Advocate Mutinyane, please confirm, it's common cause that he's an MP. And then he says, it is, my lady. I understand you are an MP. Is that correct? Yes, my lady. And this therefore means that you are gainfully employed. It is so. Your employment is statutory and therefore public knowledge. You omit any public knowledge, and it is so, my lady. So can I say you earn substantially higher than that on the Lesotho? Don't you? Yes, my lady. So much so that it would not be equitable to say a man who is gainfully employed and earns this amount of money should inconvenience the wheels of justice merely because he cannot be budgeting or wanting a lawyer he cannot afford. That is why I want you to try and make me understand your own. That's so that we can move forward. again, my lords, if that is it's a proper etiquette for a judicial officer, I would not know what I'm talking about. This is not proper etiquette. Now, and then later the accused says, as I've said, Your Ladyship, I was not expecting those fees. They came as a surprise to me. I had started paying, as I said, more than half. In truth, I've paid, and I humbly request that I should not stand in front of justice, and I apologize for the inconvenience that I've caused. So, and there are passages as well where Mr. Molapoe specifically said it is part of the fees that have not been paid, not that he had not been paid at all. Now, the aspect about Parliament, being a member of Parliament, the prosecution suggests that, well, that came after the postponement had been granted. But the passage that I've read through, I'll not take your lordships back there again, demonstrates how incorrect that position is. The issue is raised in connection with the income. But after the postponement.
And it was been, this was a discussion on the second day, wasn't it?
This is a discussion on the second day, yes.
And it was at the time when the appellant was appearing in person.
In person, yes.
And when you say it was before, when they say it was after postponement, you say no, it was when they were discussing whether or not to grant the postponement that he himself was asking.
Yes. Even earlier, even earlier, that issue was in connection with whether postponement should be given.
Yes, the one that Advocate Moahloli raised.
Yes.
And the court was not particularly pleased.
It was not abused. Yes.
So the following day, the accused came in person and he applied for postponement.
Yes.
That's when now they were discussing what he had asking.
Yes. Now, the prosecution is saying this was raised after the postponement, which the accused had asked for. If you look at page 134 of the record.
One, three, four.
134. That is where the portion that the prosecution is referring to. It says, accused, please stand up. And this passage will take me back to what happened before. The DPP has been gracious enough not to oppose your application for postponement. I also find it reasonable that we start on Thursday, because we've wasted. We would suggest that we have wasted 3 days, and I'm sure as a parliamentarian, that's where the issue of member of parliament comes in. You appreciate all this scenario, and you know about the question. How far? The translation is not very helpful, my lords. I'll try to do that. The president will correct me, because he says, how far are we so and so's case? When it doesn't make sense to your lordships, I'm sure. So what is being said here in the Sesotho is that, so in other words, what she's confronting the appellant with, saying, members of parliament ask questions in parliament, inquiring after how soon cases that are pending in a court are going to be a particular case that's pending in a court is going to be completed. Now, the way I understand the prosecution does not accept that this is a fair comment to make from the judicial officer. I understand them to say it did not influence the decision not to postpone, because the postponement had actually been granted. But as the passage itself will demonstrate, it shows a link from the beginning when Maleno Jr. was applying for postponement and the accused was now by himself. the learned judge was determined not to postpone the matter at all when my junior was doing that and when the accused were doing that. But when the prosecution does the same, she's no longer concerned about the delays. She now says, the DPP has been gracious enough to not to oppose your application for postponement. I also find it reasonable that we start on Thursday. In other words, when the application for postponement is asked by the appellant himself, she finds reason to see delays, she finds reasons to see the violation of the Speedy Courts Trial Act and so on and so forth. But you would expect that she would say the same to the prosecutor. No, I'm not postponing any matter because on principle, I'm not postponing any matter. I'm not postponing any matter which once side is ready to proceed. But now, it is my humble submission that when the accused felt uncomfortable, I submit that any other reasonable bystander would also feel uncomfortable. How does it come about that the same request? This is why I make the point, and I think that point is not quite understood by the prosecutor the way I want it to be, and I want to clarify it. This is why I make the point that a simple question of Mr. Mulab, you're asking for a postponement. I am not inclined to give postponement because I want to deal with this matter in this session. For how long do you want this postponement? That would inform her of the extent to which she could then assess the dilatoriness of the tactics of the defense, that she had now formed the view that they were now unfolding. And that is not the question that she asked. I'm not saying she was obligated to do so. I'm simply saying the question, a simple question like that would have given a clear understanding of the assessment of dilatoriness. How can it be dilatory if it's on Monday and you're asking for a postponement to Thursday of the same session in the same week? And you're saying, I am going to be able to proceed with the matter in the week. And I submit, my lords, that a reasonable fear was created in the mind of the appellant, and I'm saying it should be shared, and it's shared by a reasonable bystander who looks at the proceedings unfold. And I submit that your lordships will find that her ladyship had created an impression which could really disturb a person and create an apprehension of bias. Now, I want to go to the issue of the appointment of and I want to deal with that last. I don't want to belabor this point, but you should look at the heads. As far as the issue of disposing of trials speedily, there is no doubt about that. This court has also indicated in numerous cases that justice should not be delayed. So it's understandable that a court should take issue with the matter proceeding. But in doing so, the court should be cautious not to appear to be violating the rights of an accused person. In this particular instance, what was then happening was that because of the request that can we go and mobilize further funds to top up on the existing fees, the learned judge says, well, I'll give you pro diem. Embarrassingly, it turns out that she's wrong. the appellant did not meet the means test, and that also creates another impression. We'll discuss that, Your Lordship, the President, that it really creates a bad impression that a person should be asking for postponement and the matter is postponed for procedural purposes. Now, the same type of situation arose in the case, the Zimbabwean case, which I've shared with Your Lordships, called Mabats'oeneng. In that case as well, the judge was eager to proceed. And when the preferred counsel was asking for postponement so that it could be put in funds, the judge then said, well, I'll appoint Prodeo counsel for you. And that the Zimbabwe Supreme Court said, no, this is wrong. Of course, this court also, concerning the issue of the right of a party, when I say a party, not of an accused in this instance, to legal representation should be jealously guarded. In the Kamudi matter, the Kamudi and others, this court was very particular when the recusal application of the Chief Justice was made. That yes, we understand all that. We understand that the Chief Justice wants to finish the case. We understand that the Speedy Trial Courts Act is saying they must be finished on time. But still, that is not the only consideration. There are other considerations. And the consideration is that a party should be allowed an opportunity to be represented by its own counsel of choice. That right stops at the point where it can be said it had been abused. It stops at a point where there's an indication on the record that this right is being abused. And I submit that in line with the Mabats'oeneng and this court's judgment, in this particular case, there is not a point in the record where it could be said that the right of a legal representative of one's choice had been abused. And I submit that Your Lordships will uphold the appeal and direct that the matter be studied before a different judge. Yes, I do not want to go on and on.
Yeah, Counsel, I have one question.
Yes.
It relates to the examples of inappropriate language.
Yes.
Trickster, animal, expression on your face, and so on.
Yes.
Is an impatient or crude or rude judge necessarily a biased judge?
No.
And the second part is, does rudeness, etc., create a reasonable perception of bias?
Let me start with the first question. A rude judge, it's not allowed for a judge to be rude. But
yeah, but
okay,
that we know. But
yes,
does it mean that people don't trust the judge because of the language used? Yes,
the language used contributes towards that. But my Lord, I wanted to say, let's contextualize it this way, because on this side of the court we sometimes behave badly, and provoke rudeness from the judicial officer. So the real test would be, what had counsel done to provoke this type of rude?
No, it's okay. You don't have to go there. The court also sometimes provoke rudeness.
No.
But counsel is not allowed to be rude.
Yes.
So it's, I'm just saying that I know the language is within your broader context.
Yes.
That I understand.
Yes.
But if I think of some judges I've seen in my life and heard and appeared before, sometimes the language is very inappropriate.
I agree.
But depending on what the perception generally is,
yes,
of judges, of that judge, etc.
Yes. Your Lordship asked the second tier of the question, they're interrelated.
Yeah.
What is important is the persistence, the pattern that appears to, and when you look at this proceeding, it is not once. I'm just taking you to bits and pieces. But there's a pattern. Where you don't have a formal application for a postponement, you have generated how many pages?
Yeah, Council, it's enough, I understand.
Yes.
Especially your reference to the context, and
Yes.
I will give you a Brazilian council
Yes.
and all of that. Yeah,
Yes, thank you very much. Thank you.
Yes, on a lighter note, are you saying that judges as princesses of reason should always so remain, even if there is some slight provocation from the bar, or when a member of the bar is trying to play theater, but the judge should still remain a prince of reason?
Yes. Well, in some instances, but not always. Not always. When a practitioner is being naughty, he must be stopped.
It was just to lighten the moment.
Yes. My lord, my junior, again I take full responsibility for this, has a huge bundle. I don't even know whether you need that huge bundle really to go through, other than to go through the passages in the record. But we'll hand them up. Properly speaking, looking at their thickness, it's dereliction of duty on our part that they should not have been handed over to your lordship earlier than this, because you don't start reading when we have argued, you start reading before we've argued. I seek leave to hand them over, but I don't expect you to read this thing, all of it. I really don't. Just in case. There's a copy, please.
My lords, we have filed our heads of argument on which we submit that the application that my learned friend, Advocate Molapo, made before the court of call on the first date of hearing was that of postponement. Because by informing the Honorable Court that he was not fully inquired, or they have the powers to inquire into the reasons for postponement. And that is what the court of call in this case did. By engaging the counsel for the accused at that time, the court was exercising its discretion to find out from him whether there were reasonable grounds upon which the case could be postponed. Under paragraph 2.2 of our case, we have submitted that as per section 119 of the CPNE, the trial starts to be pending as soon as the indictment is lodged with the register of the High Court. So in this matter, on the date of hearing in September 2024, that was the 4th year since the case against the appellant had been pending. So it was reasonable for the court of call to inquire upon the reasonable grounds on which my learned friend was seeking postponement. Starting from paragraph 2.3 up to 2.6 of our head. We have shown that this trial had been pending since the 21st day of October 2022. We have referred this oral court to the case of S versus Van Hoesten, 2004, volume 2, SACR, page 478 at paragraph C, where it was said, if the presiding officer inquires as to the reasons for further postponement and concludes that a further postponement would lead to injustice, that is sufficient. End of quote. So my lords, I submit that in order to ensure fair trial, as per section 12 of our constitution, there was nothing that the trial judge could have done other than engaging my learned friends or in making the inquiry as to the reasons.
Yeah, but I say the problem is not the inquiry, but the manner in which it was done.
Yes, my lord. We submit that.
They say they have no problem with refusing or granting postponement, but the language within the context.
Yes, my lord. I will first start with the issue of being a parliamentarian. This aspect, my lords, when you look at page 7 of volume 1, paragraph 4, this aspect was introduced before the court by the appellant himself. He was the one who introduced himself as the parliamentarian. So there's nothing wrong with the learned judge by discussing that issue of being a parliamentarian in order to determine whether the appellant was capable of instructing my learned friend fully or not. So we submit that there's nothing wrong with discussing that issue. My learned friend also submitted that the language used by the judge was inappropriate. We do agree with my learned friend that the judge is not supposed to use an inappropriate language. But in this case, my lords, we don't see anything wrong with the language used by the learned judge.
Isn't it a bit dangerous in a criminal trial, which has not started yet, to call the accused applicant a trickster?
My lord?
A trickster. What is he charged with?
Isn't it wrong to call the accused?
What is he charged with?
Murder, yes, my lord. Murder.
Yeah. Okay, but now you say you're a trickster before the trial started.
You're playing tricks.
To us, my lord, when a party in a case seems to be delaying the case by the use of saying he's playing tricks. To us, doesn't necessarily mean that that is rude. That is not rude.
Okay.
Yes, my lord.
But how fair are you going to be as presiding officer in the assessment of evidence? Or rather, if he's put on his defense, you have called him a trickster before the trial starts. How are you going to believe his evidence? How are you going to say, okay, in the defense, when you are analyzing the evidence, will you say his evidence was credible?
If the judge uses that language at that stage, my lord, I would concede that at that stage, he would be making the conclusions or the decision even before the right time. As far as the demeanor or the credibility of the accused is concerned.
Because your mind is colored.
Yes, if the judge does that at that stage, my lord, not...
So that may be the gripe of the appellant, that you have already prejudged me.
Yes, my lord.
As an incredible witness.
At that stage, my lord, not
So
at
you're
this
saying
stage.
the attitude of the judge could well be that this guy who tried to trick me with regard to postponement is innocent until proven guilty, and I must listen to his evidence.
Yes, my lord. The accused is always innocent until proven guilty by the...
Yeah.
Yes.
Okay, well, I understand what you're saying. So I have no further questions on that point, but Justice Musonda gave a very concrete, good example.
Yes,
Thank
my
you.
lord. Thank you, my lord. On the day that the appellant appeared in person, we wish to submit that there is nothing wrong with the manner that the trial judge handled the inquiry. She was exercising her powers
Yeah,
of...
but counsel, you're saying nothing wrong.
Yes.
So that's perfect, the language used by the judge. You think it's perfect? Or is it at least unfortunate?
No, my lord.
There's nothing wrong with it, you say.
Yes, my lord. That is our
So
submission.
when you stand there and the judge says to you, but I don't take kindly to playing tricks, as an officer of the court, you are saying, etc. You think, you'll say, thank you, my judge, as it pleases the court, I am indeed a trickster.
No, the judge doesn't necessarily say that the counsel before him was playing tricks, but she was explaining how things have to be, or the trials have to be.
I just say what I would have found a bit more reasonable on your side is if you concede that some of the language was inappropriate, but you say it doesn't come near bias or a reasonable perception of bias, but you deny that there is anything wrong in the language used. I understand. Thank you. You've answered.
That's the purposes.
There used to be a magistrate
Yes, my lord.
who used to preside over the car theft
Yes,
in
my lord.
court. people would appear before him, we would appear before him, he would
Yes.
make statements in court, some of which I cannot pronounce from where I'm sitting. And when he uttered those statements, you would feel so offended. And then he would say at the end of the day, I am going to sentence this Seboshwa to such and such a period of imprisonment. Then he would start writing something. Then he says, I will show you who I am. Now, the lawyer would start shaking where they are standing, probably looking forward to their client going to be sentenced to 10 years. The magistrate would minute whatever he's minuting. You try to read what is written there. You can't read it as the lawyer because of the sort of hieroglyphics you would have written. Then you take the file to his secretary, and the secretary says, yes, your client is required to pay 300 money. But he would have uttered words towards counsel and the accused, which give the impression that he is going to be so hard on the accused.
Yes, ma'am.
I am raising this to say, what is the test here? I'm already trying to apply the statements that are said to have been said and which appear on record to the principles that are applicable in determining whether or not to recuse myself. Can you say these statements that were said and which are not disputed go anywhere to indicate the likelihood of bias, that an objective bystander who is fully conversant with the facts, the appropriate facts, standing there watching, would very likely come to a decision or a conclusion that, hey, this judge is likely to be biased when it comes to the trial. I think that is the crux of the case, isn't it?
Yes.
I mean, all these other issues I understand, but at the end of the day, how do they inform the principles that we are required to address at the end of the day in this case?
My Lord, in response, what transpired before this learned judge, that's in the mind of a reasonable member of public.
Who is well informed?
Who is well informed.
And the reasonable, and the accused.
And the accused as well. What transpired does not create any apprehension of bias. All it does is that whenever the accused or any person charged criminally appears before the learned judge, he or she must go there well informed that the provisions of Section 12 are at all times ensured, that the trial must proceed within a reasonable time. That is what the learned judge was trying to ensure. Yes, my Lord.
In your answer, and also taking clue from my brother, you said, and the accused. To me, that raised yet another aspect of the case. Is the consideration to be subjective or objective in determining whether there is a likelihood of bias? Are we going subjectively or objectively? What is the principle?
The principle of reasonableness, my lord, is the objective one.
Is objective?
Yes, my lord.
So, do we have to consider what could perhaps be going on in the mind of an accused person subjectively, or are we looking at our fictitious, objective bystander who is standing there but who is well versed with what should be happening in court? What is the test? What is the approach?
The approach or the test, my lord, is to consider what is going on in the mind of the well-informed member of public.
Is there something like a reasonable murder accused? A reasonable, well-informed murder accused?
Only the reasonable man or member of the public, my lord.
Yeah, no, I'm just joking because
Yes,
we have to work with innocent until proven guilty.
yes, my lord, that's the
So the
presumption.
question is, just as we say, the accused, but the accused could be innocent. And now the accused sits there and says, hey, the way this judge talks about me, I think there may be trouble ahead. I'm not sure that's really unreasonable. But anyway, you've answered. It's fully enough for me to have heard you. Thank you.
Mr. Court, Mrs. Melons. My lord, my learned friends, in their heads of argument, they have raised under count Round 4, my lord. It is not count 4, my lord, but it is the count upon which my learned friends were submitting that the learned judge did not address all the issues they had raised in their application for recusal. So in response to that, I refer this Honourable Court to paragraph 6.3 of my heads of argument, where we submit that paragraph 6.3 and 6.4. At 6.4, we submit that not every submission, issue, or ground would definitely have been addressed by the learned judge in this matter, as long as she has addressed the principal issues of apprehension of bias and impartiality. Her judgment is correct. That is the test whether a reasonable, objective, and informed person would, on the correct facts, reasonably apprehend that the learned judge has not or will not bring an impartial mind to bear on the adjudication of the case was applied. So we have referred this Honourable Court to the case of Motoko versus the Prime Minister of Lesotho at paragraph 6.
Did you say Lesotho?
No, my lord, Lesotho.
I became worried.
No, my lord. We referred the Honourable Court to paragraphs 48 and 49 of the said judgment, where it was said, I quote, "The applicant complains that the authorities cited by them in the irregular step application were not addressed in the court's reasons. However, a judge, though obliged to give reasons, is not required to address each and every submission that was advanced during the course of the hearing. As long as the reasons deal with the principal issues upon which the decision turns, they will normally pass muster. Authorities relied upon by the respondents were also not addressed in the judgment. It follows that no inference of partiality may be deduced." End of quote. We are basing our submission on this one, my lords. Mr. Court, this is my lords, the President and Justice Musonda. Any questions?
That's a good question. I've never come across this one.
Normally council thinks, thanks God, there are no more questions.
No, we have heard you.
Yes,
Not that we agree with you, but we have heard you.
Mr. Court, this is
Speaking for myself.
And the same applies to you, Mr. Thabiso.
I agree, Your
We
Lordship.
have heard you, not that we
Not agree.
No, we agree with
Yeah.
you.
No, we have heard you.
His Lordship, the President raised an important question concerning the true test. The true test is that the particular litigant himself or herself must also entertain the apprehension, and which would be shared by members of the party, a reasonably well-informed bystander. That's why it becomes a double reasonableness test, because he might very well not believe in that there's a danger, because he knows facts that perhaps are not known to other people, that we always joke with this particular individual or this giant. He would know that that's not reasonable for him to suspect that when he says something like this, that this is bias.
Yeah, the accused may be more sensitive to
Yes,
it
yes.
than somebody sitting in the
Yes,
public gallery.
yes, my lord, yes.
But
Yes,
on the expectation
yes,
of reasonableness.
yes, Your Lordship, yes. So it cuts both ways. We do not discount the appellant in the matter. The appellant is a significant and start-off point, and then we check that as against
And
reasonable.
there are also different categories as far as the public is concerned.
Yes,
There are the loved ones, those close to the accused,
yes, and they are.
and the victim. There
Yes.
are also those the victims.
Yes, yes, yes.
Yeah.
So we're talking about the reasonably well informed, who is not affected by the commotion or the emotions that are surround the situation. So, in other words, the attitude of the accused person in this particular regard, I would submit it's very important. And the issue of perceptions, it's a particularly and uniquely individualized type of situation which applies to a particular community. Communities may approach matters differently depending on what they perceive to be fair and just.
Mr. Kelly, don't spoil all the good things that you said.
Yes, no, I know what Your Lordship is worried about.
No, you don't know.
No, Your Lordship suspects that I'm making it subjective, but I submit.
I just mean don't repeat what you thought.
Okay, thank you.
That's all.
Thank you. So, Your Lordship, thank you. Now, I just wanted to point out, Your Lordship, that the prosecution misses an important aspect in the debate Well, it doesn't mean, but it disagrees that there's any impoliteness or impropriety involved. But what the prosecution does not address is whether a point had been reached where it could be said that the appellant had abused the right to a legal representative of his choice.
Yeah, but they say there's nothing wrong with it. The language, anything.
Yes, no, the language, there's the language they say there's nothing wrong. But I submit, when you look, and that's the only point I wanted to make, to buttress, is that when you look at the record, you will not find anywhere where an inference, a reasonable inference could be drawn that the appellant had come anywhere close to abusing the right to representation. And of course, the fact that a trial, the events that led to the trial happened 4 years back, does not mean that on the date of trial, a request cannot be made for a postponement, because the matter is old. The test would be to look at how he has been conducting himself relative to the trial having to proceed. Does he become obstructive of the proceedings taking off? So, and I submit that in this particular instance, there is no such evidence. And I would submit that your lordships would find that the appellant has made out a case for the recusal of the court of law. Can I ask about the magistrate?
The magistrate.
The magistrate.
You mean the magistrate?
That particular magistrate had a dark humor, so he's not a good example. He would never be a good example for a judge.
And I haven't mentioned.
I remember him. No, I know him.
That magistrate. He was my magistrate, that one. Just the mosquito. Go home. Go to a left lama. So. Oh my God. This magistrate said this. Thank you very much, Council, for your helpful submissions. We will adjourn and go and consider your submissions, and we should be able to come back with answers on the 7th of November. And we thank you very much for your participation.
There's a question.
And you are released. Yeah, excuse.